Okay, let's do that.
You may begin.
Good morning, Your Honors, and may it please the Court. My name is Miranda Jensen, and I also represent the petitioners. Today, I will discuss with you 3 reasons why this Court should reverse the 14th Circuit Court of Appeals and deny standing to unauthorized drivers of rental cars. First, as a threshold matter, the Court can avoid the issue of standing because the gun was in Officer Non's plain view at the time of the stop. Second, a bright line test is best because it reflects long-standing Fourth Amendment precedent and provides consistent rules for courts to apply going forward.
Counsel, can you tell us why the initial stop of this car was justified?
Yes, Your Honor. As indicated in the district court, the gun was in plain view of the officer and that was not contested.
No, my question is different. Was the stop of the car in the first place itself, because if the stop was illegitimate, then the search likewise was illegal. So we're not near a national border, car didn't have a broken taillight, wasn't weaving, the driver wasn't texting. Why was the stop justified?
Your Honor, this was part of the security detail as part of the President's rally.
This in spite of the fact that the stop occurred after the rally and the driver was headed away from the rally?
Yes, Your Honor. However, the officer was stopping every third car systematically, and it was to ensure that drivers leaving the rally were in a condition safe to drive home.
Oh, I'm sorry, Counsel, I thought you said the stop was justified by the security of the President.
It was a part of the whole program, and so as they were leaving the rally, they were ensuring that drivers were safe to drive home.
Can you tell us how the security of the President is related to the safety of the drivers?
Well, Your Honor, this search, the stop itself was not related to the security of the President, but rather as part of the rally itself. And so it was ensuring that if guests had been drinking at the rally, that they were not driving home intoxicated.
Is there anything in the record to suggest that alcohol was being consumed at the rally?
No, Your Honor. However, there's no indication in the record that the stop was otherwise unlawful either. And this was not a matter that was contested below, and the petitioner or the respondents even agree that the stop was lawful here.
Because this defense wasn't raised below, does that mean that this court can't consider it?
No, Your Honor. However, the respondents here agree that the stop was lawful, and it was a routine stop. Nightingale himself wasn't targeted without out of the blue. There was a systematic reason for stopping the vehicle. And additionally, once the vehicle was stopped, Officer Nan was standing outside the vehicle when she saw the gun protruding from under the passenger seat in plain view. Therefore, this court can avoid the issue of standing altogether because an object in plain view is not a search under the Fourth Amendment, and there was no constitution.
Is it really in plain view if it was partially concealed?
Yes, Your Honor, because its nature as the gun was immediately apparent to Officer Nan while she was standing outside the vehicle.
Did she say that? Did she say she immediately recognized it as a gun?
Your Honor, she said that she noticed the object was protruding and she believed it was a gun. But then upon further inspection, she realized it was a semi-automatic rifle.
It seems like even if it were not a semi-automatic rifle, but just a gun, and it was an arm's length from the defendant, that she would immediately remove the defendant from the car just as a matter of officer safety.
Yes, Your Honor. However, she noticed it while she was inspecting the documents, the rental agreement. And so after she had finished inspecting the agreement, she did have him step out of the vehicle. And at that point, she noticed that it was the semi-automatic rifle.
Did she ask permission to search the vehicle?
No, Your Honor, she did not. but she did not need permission because she realized that there was a weapon in the vehicle, and for her safety, she was able to seize the rifle without asking for permission.
If Mr. Nightingale had been a passenger in the car while Ms. Farrow was driving, would he have a reasonable expectation of privacy?
Your Honor, in order to have a reasonable expectation of privacy, it must be one that is actual and that society would recognize. And if he had claimed ownership of the firearm, then he would have a possessory interest in that. And this is consistent with the court's holding in Dycus that permission to be in the vehicle as a passenger itself is not enough. But there, if the defendants would have claimed a possessory interest of the contraband, then they could have had standing to challenge the search.
Counsel, I'm a little confused by 2 points you just raised. One is that an expectation of privacy protected by the First Amendment must be actual.
Yes, the person must believe that they have there must be an actual belief that they have an expectation of privacy in that space, and that must be a reasonable belief objectively.
And what case indicates that the expectation must be actual rather than simply potential, so long as it's reasonable? Here's my question. Must Mr. Nightingale have thought about the possibility of being stopped and said to himself somehow that if I'm stopped, I'm not, any search of me or my surroundings would be illegitimate?
Your Honor, he must have believed that he had an expectation of privacy in that vehicle. And so he did not necessarily need to consider the fact that if he was stopped, then the officers wouldn't have there wouldn't be permissible for them to search it, but he must have had a reasonable belief, an actual reasonable belief, that he had an expectation of privacy in that space.
What case says that?
In Dycus v. Illinois, the court adopts the CATS analysis, which is the 2-pronged test, into the standing analysis.
Wait, counsel, did the defendant in CATS have an actual conscious sense that his privacy would be protected when he made the phone call from the public booth?
Yes, Your Honor. He was in the public phone booth with the door closed, and so he had an expectation that no one would hear the conversation other than the person on the other side of the phone. Because by putting himself in the phone booth, he was preventing the sound from being heard by passersby. However, in the context of rental...
Let me just follow up on one other point you raised. You said that the expectation of privacy must relate to material that's discovered during the search.
I'm sorry, Your Honor?
In this case, the gun that Mr. Nightingale, in order to be protected by the Fourth Amendment, must have felt an expectation, you say an actual expectation of privacy regarding the gun? Is that, do I remember you saying that?
Your Honor, the court in Dycus v. Illinois confronted a situation where there was a passenger in the car, and the owner of the car was the one driving, and there was contraband found underneath the passenger seat. However, this court found that the passengers did not have standing to challenge the search of the vehicle because they didn't have a possessory interest in either the car or that property that was seized.
But your statement related not to the possessory interest in the car, whatever that is, but to an expectation, or in our case, even a knowledge by the driver of the existence of the gun.
I'm sorry, Your Honor, could you rephrase the question?
Yeah. What case tells us that in order to be protected by the Fourth Amendment, the defendant must have been aware, actual knowledge, or actual expectation, aware of the existence of the thing discovered in the search? The gun in this case. What case says that?
Raucous, Illinois is the closest case that discusses that matter in the context of standing. However, in the context of unauthorized drivers of rental cars, the circuits have split and there are 3 tests that have developed. And so, in the majority test, which is the best of the tests, denies standing to unauthorized drivers of rental cars because they find that an unauthorized driver does not have a reasonable expectation of privacy in a space that they don't have the permission of the owner to be inside.
So Katz doesn't apply here.
Yes, Your Honor, because in Raucous, the court collapsed the analysis of the Fourth Amendment reasonable expectation of privacy with the standing analysis. And so it found that there needed to be either a possessory or there's typically either a possessory or a property interest in the space or the
Did the
content.
defendant in Katz have a possessory or proprietary interest in the phone booth?
No, Your Honor, however, this is in the context of rental cars, and so an unauthorized driver does not have any sort of interest.
But if he paid for it, doesn't he have some interest?
No,
in the
Your
car?
Honor, and that is not enough in itself, and not enough to convey standing for Fourth Amendment purposes because he did not have the permission of the owner of the vehicle to be in that space.
Well, the owner couldn't give permission because she was locked up.
Yes,
So
Your Honor.
can't we assume that there's implied permission?
Your Honor, 2 circuits have held that implied permission or that permission, if it's explicit and direct, is enough to convey standing. In the 8th and 9th circuits, both courts have confronted situations where the unauthorized driver had explicit permission from the lessee of the vehicle to drive the car. However, neither circuit has confronted a situation or held in any or implied in the dicta that an unauthorized driver can infer that they have permission to drive a vehicle.
Well, if we look at the totality of the circumstances here, doesn't it support the fact that support a finding that he had permission from Ms. Sparrow to drive because he's the one who paid for it, he'd be the one who's responsible for any overages, she was stuck in jail, and they have a close and long relationship. Don't the totality of the circumstances then support his privacy interest?
The 6th Circuit is the only court that has taken this totality of the circumstances approach, and even that court has pulled a presumption against standing for unauthorized drivers of rental vehicles. And it was relevant in that case that the defendant or that the unauthorized driver had paid for the car. But it was also important to the analysis that they had that he was married to the authorized driver of the vehicle. So there was a legal relationship between the authorized and unauthorized driver. Additionally, in that case, the address on the rental agreement matched the address on the driver's license of the unauthorized driver. And here, it's Sparrow's address that's on the rental agreement.
In that case, also, didn't the police officer ask for consent to search? And here we don't have that, so wouldn't that tilt in favor of Mr. Nightingale?
Yes, Your Honor, in that case, the officer did ask for consent to search. However, here, that consent wasn't necessary because the object was in plain view at the time of a lawful stop. And so the officer had other reason to go into the car without that consent. Additionally, in Smith, the court indicated that those were factually unique circumstances, and so the presumption is still in favor of denying unauthorized drivers standing to challenge a search of a rental car. And here, Nightingale could not overcome that presumption. It's also important to note here that the rental agreement specifically states that no one who is not listed on that agreement can drive the car. And so under the 8th and 9th Circuit test and the Smith test, he couldn't have received permission from the lessee because she was explicitly not authorized to give that permission. For these reasons, Nightingale did not have standing, and there was no constitutional violation here. Therefore, this court should reverse the 14th Circuit Court of Appeals. Thank you.